answering affidavit to Mpho by email as soon as possible. It has not been loaded on case lines.
I think Mr. Kunda has done the
Malady?
case of.
Yes, Mpho.
Mr. Kunda has. I was submitting, my lady, that Mr. Kunda has the case of circulating the answering affidavit to everyone that we sent to them.
I've not received it. Let me see if it has gotten to me. Have you sent it, Mpho? No, I've not received it. I don't know what's happening with your connection. Okay, in any event, I do need to. How long is the affidavit?
It's 26 pages, my lady.
Okay, 30 minutes. Let's stand down until 10:30.
Thank you, my lady.
That's a court places, my lady.
The proceedings are adjourned.
That's a court places.
as complex as other matters that we normally deal with in the special tribunal. I am of the view that the applicant has set out a bona fide defense, and that the rescission application should be granted. So just bear that in mind as you try to persuade me otherwise, Mr. Kwinda. And I say so because the applicant's case is based on the proposition that the extension of the contract ought to not have been extended, and the extension is regular. That's the applicant's case, essentially. And when you read through the answering affidavit, a bona fide defense is set out on that singular ground of irregularity. That's my view of the matter. So bear that in mind. When you argue, Mr. Matoti, I'm with you, so you don't need to to spend a lot of time trying to persuade me.
Now,
Unless there's anything that you'd like to emphasize. Yes.
My lady, I will not add much, save to just add that the respondent's case in the main application did not set out a grounds to justify that it would be just and equitable that the applicant in this application must not be paid. There are also those issues.
No, that would be relevant if I find that the contract stands to be set aside as irregular, right? But your case is that the contract is not irregular because the extension was proper. And hence, yeah, that's your case.
Yes,
So the issue of just and equitable remedy does not arise, you know.
It does not arise. And the order, the only issue I'm taking, my lady, is that the order itself goes to that extent, which is why we sought for it to be rescinded as well, because it says they're granted leave to recover. There must not be payments.
But you didn't make out, did you make out that case in the rescission application?
We did, my lady. I think it's...
Yeah, but remember, they're also saying that you've not provided proof that the services were rendered. So their version is that the services were not rendered.
No, right. we placed that in dispute, and we deal when placing that in dispute with their paragraph where we said...
Yes, I'm sure they'll reply to that. Because they wanted the contract set aside on the basis that the extension is irregular and no services were rendered. So you're coming in reply and you're saying the services were rendered, right?
Yes.
Yeah, so, but you're not dealing with the issue of just and equitable remedy yourself in the answer, did you?
We did, my lady.
Oh, you did? Okay, I didn't read that far.
I think if the court goes to... If the court goes to paragraph 18 of the answering affidavit, the main answering affidavit.
18. Let me see. I didn't read that far. I just looked for specifically what I was looking for. And when I found it, I didn't need to read further. So paragraph 18.
Page 18, it's paragraph 61.
Paragraph 51.
61, my lady.
Okay, paragraph 51 doesn't deal with that.
61, my lady.
61.
61, yes, it's at paragraph it's at paragraph 53. In fact, my lady, it starts from at paragraph 52, from 55 to 61. We deal with those pertinent issues relating to the contract and rendering of services.
Okay, I've seen it. I'm battling with the network this morning. I don't know why. I've seen it, Mr. Matoti. Anything further?
Nothing further, my lady. Those will be our submissions, my lady.
Okay, Mr. Kwinda.
As a court places, my lady. My lady, I have 2 submissions to make.
I'm battling to hear you.
My lady?
Yeah, I can hear you now.
I have 2 submissions to make, my lady.
Perhaps you should leave. Can you hear me clearly, Mr. Matoti?
I can hear you clearly, my lady.
No, I think the problem is on my side. Okay.
You just froze. That's the only problem.
Pardon?
Your picture is just froze.
The network is very bad. Yes. Can you hear me clearly, or is the interruption on my side?
Judge, I can hear you clearly. It's just that we can't see you. But
pardon?
We can hear you clearly, Judge. We just can't see you because you have your frozen picture on the screen.
Okay, can you see me now?
No.
I'm battling to hear all 3 of you, so I'm going to leave and come back.
All right.
Court, please.
The court, please, my lady.
Okay, can you hear me now?
Yes, my lady.
Yeah, it's
yes,
my lady. Yes, thank you. Mr. Kwinda?
Thank you. As a court, please, my lady. My lady, I have 2 submissions to make.
Yes.
It is the first respondent view that your ladyship, one should have not considered the applicant answering affidavit on the following grounds. One, is not stated in the funding affidavit in the recent application which paragraph the applicant is relying on with regard to the bona fide defense. And your ladyship...
Isn't that an overly technical point?
It is not.
That's an overly technical point, Mr. I would have had regard to the primary papers in any event to determine whether a bona fide defense is made. I went there precisely because the issue around the validity of the extension is raised in the founding affidavit in the rescission. That's why I wanted to see how it's dealt with in the answer. I mean, that attracted me. So I'm not sure what you mean. That's an overly technical point. In any event, this issue is dealt with in the founding affidavit in the rescission application.
Your ladyship even said that it is the first respondent submissions that one even look at the founding affidavit.
Yes.
We have stated that in our answering affidavit together with our heads of argument. And it's still the respondent submissions that the applicant failed to make out a case for bona fide defense in the founding affidavit. And instead, what the applicant did, they've referred the court to their answering affidavit. One, without telling the court which paragraph they are relying on, or one, it will be expected of them to state their respective defenses from the answering affidavit in the founding papers, so that when the first respondent answered to the founding affidavit in the main application, in the recent application, to respond to the alleged bona fide defense. But in this case, Your Ladyship, it is still the first respondent submissions that the leadership will recall that on paragraph 16, page 6 of the first respondent answering affidavit of the first respondent heads of argument, we rely on the matter of the NDPP Mpo?
Advocate Quinda?
Yes, I don't know why I'm battling with the connection today. I mean, last week we had a hearing that went on for 5 hours and it was fairly smooth.
Okay, leadership. Well, our point is, what having it will be
the connection is still very bad. I don't know what to do now. Can you hear me?
Yes, I can hear your leadership.
But you're breaking.
Okay, I can hear your leadership. Our submission is that your leadership, the leadership cannot.
I can barely hear you, Mr. Quinda. Okay, let me leave and come back again.
Okay.
Okay. Can you hear me now? It should be better.
Okay, we can hear your leadership.
Okay.
Your leadership, it is the first respondent submissions that the special tribunal is bound by the judgment of the National Director of Public Prosecutions and others versus Zuma. The citation is on page 6 of the first respondent heads of argument. That is 2009, volume 2, SA 277 SCA at paragraph 26 and 27 of the said judgment. The principle of the said judgment, the leadership will find that on page 6 of the first respondent heads of argument, in which it stated that it is not proper for a court in motion proceeding to base its judgment on passages of documents which have been annexed to the papers when the conclusions sought to be drawn from such passages have not been canvassed in the affidavit. The reason is manifest. The other party may well be...
No, Mr. Quinda, I'm still battling to hear you. Can you hear me?
I can hear your leadership.
I can
check your network. Mr. Matoti, can you hear me clearly?
I can hear you clearly, my lady.
Okay.
I can hear you.
I can also hear you, my lady.
I don't know where the problem is. I've even changed networks. Okay, try again, Mr. Quinda.
Thank you, leadership. We're saying it is the first respondent submissions that the leadership should consider and also is bound by the judgment of the NDPP versus Zuma, the 2009 volume 2 SA, SCA at paragraph 26 and 27, as quoted in the first respondent heads of argument. And I've quoted the relevant paragraph there. The Supreme Court of Appeal stated that it is not proper in a motion court proceedings that the judgment be based on the document, on passage in the document which have been annexed to the papers, when the conclusions sought to be drawn from such passages have not been canvassed in the filing affidavit. In the affidavit, my apologies. The reason is manifest. The other party may well be prejudiced because evidence may have been available to it to refute the new case on the facts. A party cannot be expected to throw through an extra to their opponent affidavits and speculate on the possible irrelevancy of facts therein contained. Having said that, Your Ladyship, we are saying that if one have regard to the founding affidavit in the resolution application on paragraph 24 to paragraph 30.
I'm really battling to hear you. I don't know what should I do? I'm really battling to hear.
Yeah. Can you hear me now, Your Ladyship?
No, I'm still battling. Okay, let me try and connect from another device and see if that works out better.
Okay.
So, Mr. Kwinda, can you hear me?
I can hear you, Your Ladyship.
Mpo, please check the lobby and let me in.
My lady, I do not have an invite in the lobby.
Pardon?
I do not have your invite in the lobby.
You can't see me. Okay, let me try again. You still can't see me?
No, my lady, I can't.
My lady?
Yes.
Okay. That's a call, please.
I'm still battling to hear you. Mpo, can you see me now?
No, my lady.
This is very strange. Okay, let me leave. Oh, no, now I'm in. Okay, let me. Can you hear me now?
Yes, I can hear you, Your Ladyship.
Yes, it's so much better now. Okay.
Yes, I can hear you. I can also see you, my Ladyship.
Yes, okay. That's fine. Let's get working.
Okay. Thank you, Your Ladyship. Your Ladyship was saying, as the first respondent, Your Ladyship cannot rely on the answering affidavit in which, in their founding papers, one, they fail to refer the court, the special tribunal, to the specific paragraph in the answering affidavit, or to state it, and to show their prima facie defense. And one, even having regard to the applicant funding papers at paragraph 26. Paragraph 26 of the funding papers of the answering of funding of the rescission application. It says, to this end, it is the first respondent quotation that nothing could be further from the truth regarding to clause 21.2 of the general conditions of contract, which reads thus. They've made reference to clause 21 of the general condition of the contract. Again, one even regards what they've stated under paragraph 26 of the funding affidavit. The done, again, Your Ladyship, if one can I go to paragraph 27. Then they also make a reference to clause 18.1 of the contract. And most importantly, Your Ladyship, paragraph 29. This is where I was coming to. They've said that in the answering affidavit, it deals with how the irregularities were dealt, and also the legislative prescript and the treasury regulations. That is all that they're saying to the Ladyship. They don't deal specifically with the allegations of prima facie defense. And also, Ladyship, if one have regard to the answering affidavit of most importantly paragraph 52 and 53 of the answering affidavit, we said, I state that the door-to-door campaign was never the scope of work under ORTDSMU 05-18 of 19. And furthermore, paragraph 53, we state that the tender to conduct the campaign was awarded to applicant Phathilizwi to perform door-to-door education on COVID-19 in the district of OR Tambo municipality under extension tender number ORTDSMU 05-18 of 19, without following the procurement procedures and not complying with the provision of section 217 of the Constitution. We've mentioned that, Your Ladyship. And most importantly, on paragraph 54 of the answering affidavit, we stated, I state that during COVID-19, there was restrictions of movement and people were confined to their homes and except essential workers, and it was never possible for the applicant and or its employees or agent or contractors to perform the alleged door-to-door campaign education with regard to the COVID-19. Your Ladyship, our point is, one, even regards what the applicant stated in the founding affidavit, paragraph 29. They don't tell us exactly which paragraph that they're relying on. They didn't mention in the founding affidavit, and we're saying that, Your Ladyship, one would have expected the applicant to make their case in their funding papers. And as I've stated, Your Ladyship, I need to re-emphasize that the Ladyship is bound by the judgment of the NDPP versus Zuma. And again, Your Ladyship, I'd like to refer the court to the matter of PATMA is PATMAR versus Limpopo Development Tribunal is 2018, volume 4 SA, page 107 SCA, and of most importantly is paragraph 4 of the judgment at page 110. And in that said judgment, the Supreme Court of Appeal held the doctrine of state diseases is one of is one that is fundamental to the rule of law. The object of the doctrine is to avoid uncertainty and confusion, to protect vested rights and legitimate expectation, as well as uphold the dignity of the court. It serves to let certainty of the law. In those circumstances, the bar that the tribunal set itself to clear in this case was high. It made no attempt to clear it. In fact, the response to the question from the bench counsel respondent, we were not necessarily saying Shelton is wrong. That renders it unnecessary to engage in any detailed examination of the judgment. Your Lordship, what the Supreme Court of Appeal is saying here is stated that the court.
Yes, just continue. I'm just trying to get rid of this slide. Sorry.
Okay, so
just continue. I'm listening.
All right. Is that the doctrine of state should be followed, and that is a fundamental of our law. And Your Lordship, even referred to that judgment, we're saying that there is a Supreme Court of Appeal judgment which I've made reference to earlier, and it is our respectful submissions that Your Lordship is bound by that judgment. And Your Lordship, having said that, it is further, there is first respondent submissions that no bona fide defense have been stated in the filing affidavit, and therefore the applications tend to be dismissed. Of course, Your Lordship. And again, Your Lordship, I need to emphasize the point that it will have been expected, is always being expected of the applicant in the filing papers to state his defense. And you cannot come and rely on other affidavit in the present case of documents which has not been stated in the filing affidavit. And having said that, Your Lordship, it is our full submissions that the applicant failed to make out the case in the filing papers, and therefore the applications tend to be dismissed. And it is further common cause, Your Lordship, that there is no replying affidavit to the first respondent answering affidavit, and therefore Your Lordship should find in favor of the respondent, as per the vision that to date remain undisputed by the applicant. Your Lordship, again, having regard to the filing affidavit in the rescission application, it is clear or is common cause that the applicant was aware that the matter was set down on the 20th of April 2021. And furthermore, Your Lordship, is common cause from the and based on that, there was no application for postponement that was lodged by the applicant timely in order to inform.
There's a lot of feedback noise. Can everybody please mute themselves except for Mr. Quinda? Mr. Quinda, I hope that paging is not happening in your chambers.
My apologies.
There's somebody going through pages and they are making noise.
My apologies. It was me going through the answering affidavit. My apologies, Your Lordship.
Okay.
Okay. Your Lordship, having said that, we are saying that there was no application that was brought timely by applicants for condonation or alternatively for postponement of the matter, despite being advised by the first respondent that they were supposed to have filed the answering affidavit. And Your Lordship, one would have expected the applicant that will have brought that application timely for condonation for non-compliance with the court order that Your Lordship have granted. And Your Lordship was saying that based on the conduct or the actions by the applicant, that shows again a willful default on part of the applicant, and was saying that the Lordship should not grant.
That issue really has to do with procedural recalcitrance on the part of the applicant. It doesn't go to the root of the matter where justice lies. So that conduct is it not the type of conduct that can be remedied by way of an order as to cost, rather than deny the applicant an opportunity to be heard under circumstances where a bona fide defense is displayed in the answering affidavit? And I know that the condonation application is contained in the answering affidavit. You see, if there was no condonation application altogether, I would understand. So what transpired on the 20th of April with the applicant not being in court is now water under the bridge. That has happened. There was no postponement application before the court. The answering affidavit was, I was informed of that affidavit while I was about to grant the order, and in the absence of a postponement application, I wasn't inclined to even have a look at it, but that's water under the bridge. It has happened, and now there's a rescission application here, and the test is whether the applicants showed good cause for the default. And they explained why they were not in court. And then, whether a bona fide defense has been set out. Now, you need to remember that the court is not technical in evaluating these requirements, right? So where the applicant's case is weak in showing good cause for the default, but there's a clear bona fide defense set out, the court is inclined not to shut the door on the applicant, but to allow the matter to be heard on the merits. If there was no bona fide defense set out, then the fact that they've showed good cause would not assist them, But the court evaluates these two requirements as a seesaw and not in isolation from each other. Where you can fault them is that in the rescission application, they failed to explain why they were not in court on the 2nd. They explained that in the main affidavit where they apply for condonation. But why should I ignore that? It's before the court.
Your Lordship, it is the applicant's submissions that the applicants stand and fall by their founding papers. In this case, the founding affidavit in the rescission application. And Your Lordship will see on page 8, footnote number 13, I've made reference to the decided cases that deals with the rescission of the default judgment under common law. And Your Lordship, our submission is that if one have regard to what is being stated in the founding affidavit, the applicant has failed to make out the case of a bona fide defense. And
would you have anything else? You've already made that point, Mr. Kwinda. Do you have anything else that you'd like to address me on?
Your Lordship, the other issue is that in the event that Your Lordship has considered the judgment of Zuma and others and find that the applicant are entitled to the rescission of the default judgment, and which is still the defendant's submission that no proper case has been made, and therefore the applicant should be ordered to pay the cost. Your Lordship, I have no further submission to make.
Mr. Matoti?
My lady, I'll be very brief and perhaps just make the following submission first. The court has indicated that we were not present on the 2nd. That may not be entirely accurate. Mr. Gonya appeared for the applicant in the rescission on the 2nd when it was postponed to the 20th.
No, I meant on the 20th of April. You were not in court.
Yes. The court said the 2nd. Thank you, my lady.
I meant the 20th.
And the 20th, we explained that we got the information that it will be heard.
No, that's a very weak explanation, actually. I considered that you had not complied, right? So the application proceeded on an unopposed basis because you had not filed an answering affidavit.
Yes.
So in fact, the court did not owe you any duty to inform you on how the proceedings were going to proceed on the 20th, because the application was unopposed.
I take that, my lady. Those were the 2 points I wanted to make first, just to clarify the issue of the second, and it's clarified that it's actually referring to the 20th. The second issue, my lady, is the case of Zuma that is referred to. My lady, the court correctly points out, my learned friend is placing form over substance. And this was, excuse me, this was dealt with in the case of Swiss Barrow, where voluminous documents are just attached without pointing to a specific paragraph. And that's the genesis of that principle, to say, you at the very least tell us what you want the court to deduce from those documents. And this is not a voluminous matter. It's a straightforward 26-pager, notwithstanding, in the founding affidavit for rescission, we've actually quoted what would appear in the contract itself. So it can't be that we are supposed to go back and refer to a paragraph when we've quoted.
In fact, Mr. Gwinda is correct. I didn't have to look at the answering affidavit, because the bona fide defense is set out there. And it's exactly those paragraphs that attracted me to look at whether, if this application is served before me, would I be satisfied that a bona fide defense is set out? So those paragraphs are referred to there.
Yes,
I didn't even know in which paragraph in the answering affidavit are they referred, because those paragraphs do set out a bona fide defense. I just needed to have regard to the answering affidavit as a whole.
As the court pleases, those will be our submissions, my lady. Insofar as courts be between the hands of the court, we can't boldly submit that they've been malicious in opposing the application for rescission, and we'll leave it to the discretion of the court. Those will be our submissions, my lady.
Okay, thank you. Thank you. The proceedings are adjourned.
Court pleases, my lady.
Pleases, my lady.
Judgment is reserved.
Court pleases, my lady.
I'm going to hand down an order in the event that the rescission, I'm upholding the rescission application. I'll just hand down an order, right? Because that order is not appealable. However, in the event that the applicant is unsuccessful, that's when I'll prepare judgment. So don't be surprised when you just get an order.
Court pleases, my lady.
As a court pleases, my lady.
Thank you. Judgment is reserved. The proceedings are adjourned.
As a court pleases.